Okay. Good morning, everyone, and welcome to Best Practices for Marijuana in the Workplace. I'm Vinny Civitello, Communications Manager for the New Jersey Business and Industry Association. With us today is Judy Saylor of Primepoint. Primepoint is an official affinity partner of NJBIA, and as such, you can receive discounts on their payroll processing services and human resource management system. For more information about that, visit us on the web at njbia.org. A few housekeeping matters before we get started. Today's webinar is being recorded and will be emailed to you tomorrow along with the PowerPoint for today's presentation, so be on the lookout for those. If you just can't wait, you can download them right now from the Handouts tab, but I'd also like to draw your attention to the Questions tab. Judy would be happy to take all of your questions, so don't hesitate to write them in as soon as they come to you. And I can't stress that enough, write them in as they come to you, or you might forget what you wanted to know by the time we get to the Q&A. So now let's get things started. Judy?
Good morning, everyone. So we're talking today about the best practices for marijuana in the workplace. And the big reason for that is first that the medical marijuana plans have changed due to a few legislative pieces. But another part that is definitely shifting is the opinion of it being legalized. We've seen a shift in the last 50 years that's basically flipping the numbers, and folks are more apt to say to legalize it than they're not. And I know folks would say, oh, it's those darn young people. But the reality is every generation of people has changed their opinion of it and has increased in the percentages of allowing it to be legal or not. Executive Order 6 is what started all of this conversation this past year, and it's where Governor Murphy has signed into law, has amended the current medical marijuana law and added several debilitating medical conditions, which those conditions open up a whole new cadre of items. In this executive order, they reduced the registration fees. So in order to have a medical marijuana card, first you must be prescribed by a physician, and then you must register with the state that you are a user of medical marijuana. Those fees in the past were much higher, and so they've chosen to bring them down, especially for seniors and military veterans, so that they could get the care that they needed. The Honig Compassionate Use Medical Cannabis Act is this big addition that has been made to medical marijuana. And what do we see? We see a couple of very familiar items that folks could have based on, our ages or our health conditions. The two that I see or three that I see and hear the most of people talking about is anxiety, migraines, and chronic pain. And those were added this year to the list of items that can allow someone to receive medical marijuana. The concern here is, and I'm sure all of you have watched the news, but we have Dr. Starkman in Bordentown. He's prescribed over 1.4 million doses of opioids. Doctors are going to have that level of responsibility to understand who they're prescribing this for and what ramifications there are. This could be another opportunity that ends up out of control once we start to look at the data in a year or two. The executive order stipulates that anyone who is a qualifying patient cannot be discriminated against. They can register for college, they can register for institutions of any higher education, they can rent or lease property. That would mean leasing an apartment or potentially a vehicle. They have the opportunity to get licenses and certifications just like everyone else does in the state of New Jersey. And those licenses are things like, CNA, LPN, RN. Are those areas where we're going to see changes? Yes, I would tell you that I could see those areas tightening up dramatically in order to protect the client base that they work with. However, one of the big pieces that's here and that folks potentially need to focus on for themselves is that you are not required to take any action that's going to jeopardize a monetary grant that you're receiving as a result of a federal law. And what this means is, you can have a drug-free workplace. It is absolutely acceptable. The list of regulated industries is far and wide. Now, there has not been any guidance yet from the state on the specifics of the regulations for these industries. Each of these industries is funded in one way or form through the federal government, either through audit, either through direct support, direct payment, etc. And so, right off the bat, in my mind, I would think finance and banking are two areas that medical marijuana could be a no-fly zone and would not be permitted, even in the medical sense, because of the important data and information that one is utilizing at work every day. In talking to several unions, the DOT is not going to accept a medical marijuana card. You won't be driving because their expectation is you are going to be able to pass your DOT physical and as well as the health assessment part. And someone on medical marijuana would not be able to complete or pass that based on the questions that they are required to answer. So the next that we see is that an employer cannot take any adverse employment action against an employee who is a registered identification card holder. The difficulty here is, say someone comes in to interview for your office, say several folks do, and you do a background check and you send that background check information in, and one of those people comes back as positive for marijuana. Well, now in the state of New Jersey, you need to give them 3 days to present their medical marijuana card to you, because legally, during off-duty hours, they would be allowed to utilize that. The tough part here that we're seeing for employers is, say you choose not to hire that person. If you would consider it an adverse action towards you, that this person would be allowed to have marijuana in your facility or use it prior to coming to work. In Pennsylvania, the first case has just occurred where one was denied employment because of a medical marijuana card, and she sued the organization and won. Nothing in the law says that a damaged employee in their mind doesn't have the right to sue. They are able to do that now. And as you all know, once you see one court case, you will see the floodgates open because folks now know what to look for. Nothing in the bill can restrict an employer from saying you cannot bring the substance to the job. You cannot go out to your car to quote unquote have a cigarette, but when you're actually taking a marijuana break. The majority of us are actually very fortunate in most businesses because one of the first laws that there is a smoke-free workplace. And by having that, many people have smoke-free campuses or facilities. That supports the marijuana issue. If you want to be a no-fly zone, so to speak, you can utilize the smoke-free workplace as well as the drug-free workplace. And you would need to put that into your personnel policy. If it's not written down, it doesn't happen. It needs to be in the personnel policy. We've had at least 6 different reasons this year to update personnel policies and send out new copies. It's December, we need to get to it. As an employer, you can continue to do your drug test as you have, potentially random, I would hope, being done correctly. You can't have the same person always get called every time it's a quote-unquote random drug test. And this is still in accordance with state law. And again, if a current employee now shows up positive for a random drug test, they have 3 days to come up with a legitimate medical explanation. And my concern, and as a forward-thinking person at times, we're going to see potentially doctors who we're going to start seeing more and more of our employees within one building. And that's going to be difficult. We're going to really have to pay attention to and plan for this with our policies and our communications to staff. Physicians are allowed to opt out of the public list that will be distributed through the state, through the Department of Health, intentionally, they don't want people to recognize that they are a prescriber or would be a prescriber. They don't want that flood of folks like the doctor in Bordentown who would continually come in for product. There may be really good reasons for it. The J. Honig compassionate law came because of a little boy who was suffering dramatically from a brain tumor that had been operated on and then came back in full force. And his poor parents watched him suffer through pain. At that time, he was only prescribed small doses, and it was literally not enough for him to manage the pain over a 30-day period. And so his parents fought after his passing to make sure that no one else who had such significant health conditions would not be able to get, that they would be able to get the medicinal value that they needed. Unfortunately, as we know, there's always a percentage of the population that's going to take advantage of that and do things that many would consider inappropriate. They've elevated the medical marijuana into the Department of Health. To me, this is one of the first steps in saying recreational marijuana is coming. I've been saying that for a while. I read pretty much consistently about all of these statutory issues and legislative issues. There are steps that are going on that I would tell you, it's a pretty good bet it's coming. They expanded those forms, and now they've expanded those forms to be able to vape-like cartridges. This is a big issue, and I'm sure if any of you have offices in New York, you know that New York is looking to ban vape altogether. So how do we combat this? How do we manage it? Because sometimes it is a question of managing the risk. We start looking at first the federal law, and we know that marijuana was made illegal in 1937 and that it became a controlled substance in 1970. 1988 is the drug-free workplace, and this hinges first on federal contractors and those receiving federal grants. Those are those industries that are receiving funding. It moves into some of the requirements that folks have to do, i.e. create and communicate your policies. One of the big things you need to look at your policies on, and we'll look at that towards the end of the presentation, is that you need to define what is inappropriate behavior. What are actions that would have somebody written up or disciplined in some way, shape, or form relating to having medical marijuana? You can take the traditional programmatic steps and look at, it's unlawful to manufacture, distribute, dispense, have possession of, etc. You can't control your staff once they're off your property. However, we know that they have off-duty hours where they're permitted to do what they like. The federal enforcements are interesting in that, they talk about the distribution or avoiding the distribution to minors and avoiding the sale of marijuana to support criminal enterprises. One of the big ones that we see here is this preventing state-authorized marijuana activity. And some of you may know, Nebraska and Oklahoma sued the state of Colorado over the fact that its legal marijuana was coming over the border to them where it is illegal in their state. And they were finding an increase in the use in their state because that legal marijuana was coming over. At several points, the case has gone back and forth. I honestly can't even tell you if it's been finalized, but I find it fascinating that three governors, consider taking each other to court to manage this. Some of the intent of the federal enforcement is that you cannot drive while impaired. And that doesn't change on the New Jersey side. That is the expectation. You will not drive with impairment. The bigger other pieces that we look at are is that an individual may not be a grower of their own materials. The marijuana that is used in the state of New Jersey is grown at dispensaries. And we'll take a look at that in just a bit. So how did New Jersey get to here at this moment, right in time? Currently, we spend $127 million on marijuana possession enforcement costs. We know that Philadelphia enacted a new rule where you can carry up to 30 grams. You only get a $25 fine, no jail time, nothing. If you are caught smoking it, it's a $100 fine. And the intent was to take some of the pressure off of law enforcement from dealing with more minor issues than dealing with larger issues with constituents. So, you know, we're looking at that's $127 million in the budget that could potentially be saved somewhere. The intent is that it is subject to an excise tax of $42 per ounce, and that is on the grower's side. If it were to be in the recreational version, there is a tax for the grower, there's a tax for the distributor, there's a tax for the storefronts. And the distributor and the storefronts each get taxed by the local municipality also. So this is a moneymaker. The budget right now for 2020 has $60 million in it as tax revenue for 6 months. Rutgers did its predictions looking at the budget, and Benfield came up with it's anywhere from 118 to 173 million per year that we could generate in tax revenues. Everyone wants to have the conversation about property taxes going down. That's why New Jersey is where it is. This is where the dollars and cents come into play. Currently in the country, we've got 33 states that provide medical marijuana, and it's everywhere from Arkansas to Connecticut to Florida to Maryland, Massachusetts, you know, New Jersey, New Hampshire, you name it, the majority of them have bought into this. It is still illegal under federal law. That's why industries that are federally regulated in some way have an out because of that federal law. It's still a Category 1 narcotic. And one of the big things that occurs is that banks are not permitted to take deposits of marijuana money. It's considered money laundering. And that's the ill-gotten gains concept. One of the big issues that Colorado has had is that all of the industry of marijuana in the state of Colorado is handled with cash. They have 2 to 5 ton safes in their facilities. All the cash comes in, they pay their employees in cash, they pay their electric bill in cash, they pay their mortgage in cash. And the state is starting to recognize that, quite honestly, they could be losing a lot of tax money because of that. So the state is looking to develop, or was last year, was looking to develop a federal or a state credit union, which would abide by the state rules and allow those individuals who run those types of businesses to deposit money. Now, would they still be able to use debit cards and credit cards? Potentially not, because those are backed often by federal investment opportunities. The opportunity for someone to have cash on hand like that just asks for criminal actions. It's just inviting danger. You know, it takes you back to the Prohibition years and inviting the problems that could come with it. However, the Safe Banking Act, which would prevent federal banking regulators from punishing banks for working with illegal cannabis, is coming. They're working on it right now on Capitol Hill. Its intent is to allow banks, TD, Ocean First, you name it, to be allowed to accept payments and not have any repercussions. Part of the repercussion piece is that FDIC insured. That would, if you accepted that medical marijuana pricing or cash, you would become ineligible for FDIC. They will not protect that fund. So this is moving, and both local, state, and the federal government are recognizing they're losing a lot of tax money by not having that money go into banks. And banks are losing money for their investment opportunities. So where we got to with marijuana in the state, we were looking at the legalized bill at this point. It moves to expand the medical marijuana even further with Executive Order 6. It is at this stage, quote unquote, potentially a referendum for vote for election 2020 as a vote by the people and at their voting centers. The Senate is moving forward to expand the state medical marijuana program, meaning they want to decriminalize certain rates that you may have in your possession. They want more facilities that are guarded and protected and kept properly in care that will grow marijuana for its medical purposes, as well as for use to sell for recreational purposes. The decriminalization is, again, just like Philadelphia. They're going to do fines, and there's going to be no jail time for it. If those records are expunged, personally as an HR personnel, that makes it really difficult with hiring at times. You know, if you work in an industry where, say, for example, you have more delicate individuals, children, the elderly, people with disabilities, folks will be able to apply for positions now, and their records would be expunged from certain types of occurrences they had. The big piece that the legalized recreational version would do is create a cannabis regulatory commission. It would be a group of 5 chosen people that we're going to monitor, one of which being from the actual industry of marijuana, of course, regulators on the state end, and then, excuse me, someone from, I'm sure, the either prison system or state police, in order to define, you know, what, as reasonable and rational adults, what is acceptable, what is not. The intent would be is that you could be 21 years of age and possess up to 1 ounce. The employer still will have the right for drug testing and a drug-free workplace. However, the pieces there are going to be that you can prohibit an employee from being an influence under the workplace, and you can prohibit them from bringing it, but you can't prohibit them from using it during their personal time. So our commission has state representatives, state branches such as in order to study, advocate, adjudicate against forms of social injustice or inequality, and additionally, all members would possess education, training, and experience with legal policy and criminal justice issues, corporate or industry management, finance, securities, or production and distribution. This group would be a group of, you know, one would hope, highly trained professionals that would report to the governor through the designated chair and would be able to support this being a business entity. Colorado did something similar. It has what they call their cannabis czar. His job is to basically meet and wrangle with all of the departments in the state. So health and welfare, education, you know, the FDA, any group that is an office within the legislature, they meet and they work out what are the industry issues that are crossing over into those. What do we need to do? One of the first things that they had started to tackle when they first became legalized was edibles. Early on, there was a young 18-year-old gentleman who had gone out on spring break and had some edibles, and unfortunately, you know, went to his demise after jumping off of a balcony. There was a big outcry about it because the edibles look like, quite honestly, children's candy, gummy bears, Sour Patch Kids, things that any child could pick up and in their mind would be candy. That's what they would eat it for. And so, excuse me, one of the big things they opted to do was require a major change in the packaging of items. Our group, and as you know, Sweeney, is looking at the issue of packaging for these things. It can't look fun. It can't look like something that a child would mistakenly pick up. This is what one of the cultivating plants looks like in the state of New Jersey. There are, I believe, 4 right now, and 2 more are waiting in the wings to be built. It's just like growing. You know, you could grow tomato plants in there. It'd be the same kind of thing. Several areas in Burlington County have considered bringing growers in, really because they need ratables in their communities for their tax base. And that's really what this is. It would become a new industry inside of our state. So the amendment does not restrict you from taking adverse actions for the possession, use, intoxicating substance during work or on workplace premises. You don't allow people to come to work drunk. You don't allow people to, at lunch, get drunk. You don't have to allow them to be under the influence utilizing marijuana. Same thing. There is the carve-out still for lawful off-duty use. However, it still violates federal law. And so if you get pulled over, you can be bound by federal law by the police department as of the moment. Additionally, the rules include some changes that would go into effect upon publication, meaning they're not in effect yet. They will be creating a permitting system for all the cultivating and manufacturing and dispensing. Colorado's big project that they did was a huge dispensing project where every bud is tagged. It has an RIFD tag. They know exactly the place and plant and batch it came from, who created it, etc. And the intent was to be able to track this if it got into the wrong hands. So they'd be able to, manage that for the police department with the police department and their support. They do want to streamline the process more for those with a debilitating medical condition. And currently, there is a requirement that if you are prescribed this, you need to be referred to the Medical Marijuana Review Panel. And they're going to re-examine why your doctor has made this choice. And then if they say yes, that is when you would be purchasing your permit. There would be an emphasis from the Medical Marijuana Review Panel, because they should be able to provide a level of care information to the state health commissioner in regarding medical marijuana use. They're the ones that are currently reviewing it all. They're the ones that make decisions. They should have the data to back up and support the decision-making process. They're also looking to remove the requirement of a psychiatric evaluation and as a condition of a physician certification of minors. A minor is not obviously the same physically as an adult. Adults would still be required to have that psychiatric eval. A minor with a debilitating diagnosis is already being evaluated by the hospital and their doctors in order to be sure that they're giving them the right level of support, including potentially medical marijuana. Nothing in the public law says that you're allowed to drive using marijuana and be under the influence. You are not allowed to be impaired. One of the big things that's occurring right now is that several states out west are using the opportunity to do roadside testing. We'll get to that in a little bit. The public law does not mean to supersede any laws related to driving under the influence. So if you go through a mandatory check, you are bound by all of those laws with those officers at that point. And driving impaired can be by marijuana or edibles. Cannabis items is the catch term for all of the other different options you can utilize that would have medical marijuana or marijuana in them. So the effects on the employer, you cannot take adverse action right now against an employee. However, if you can show, much like other areas, that there is a harmful impact to your business, or that the job the person is doing could be dangerous for everyone else in your facility, then you can make certain decisions. There has to be a rational basis for it. Very easy one. You work in a place where there's a loading dock and you have forklifts. The person driving that forklift could not be a medical marijuana user, could not partake in recreational marijuana. Why? Because it's a major safety issue. You know, your reaction time's different. Everyone who would ever use it, the amount of time it takes to degrade in their system is different than every other person. So there are jobs in your facility that you would say absolutely not. The other impacts on business. Right now, we are seeing 2/3 of illicit drug users are full-time employees somewhere. Think about that. Think about your office right now, 2/3. We know that 1 in 13 have an alcohol use disorder. We know that 1 in 12 people have used marijuana in the past month. Think of the number of staff you have. Count them off in 12. And then look at how many people have potentially tried this, socially or otherwise, in the last month. And then 2 in 3 people are abusing prescription opioids, and they're currently employed. And what does that mean? We've all heard the term functional alcoholic. There are times that we are going to start hearing functional opioid user, functional, pothead. These are not acceptable terms, but this is where the description is going to end up at, because there will be people who utilize it who function at a different level than they would have without it. So some of the impacts, again, are on the legal compliance side. You can maintain a drug-free workplace. It has to be in your personnel policy. It has to be on any notification you give to staff about having a drug-free workplace. You can abide by both the state and federal law. If you have offices in other states, you need to check and see what is their expectation. Are they going to hold your employees to the home office's standards? Or vice versa? The next piece is looking at complying with ADA. And ADA at this point has not said that medical marijuana must be an accommodation for people. As I'm saying that, that could change tomorrow. We don't know what's going to happen. The legislative process is going to be what hashes a lot of this out. And, as I said earlier, we saw our first court case where someone who was denied employment was able to sue the potential employer. So ADA is going to look to you and say, this person has a debilitating issue. What was your interactive process to determine their accommodation, their needs as your employee? That interactive communication is really going to become much more critical now and needs to be done, with witnesses, with documentation, with all of the right, I's dotted and T's crossed. We are seeing, as a result of the changes with marijuana across the country, healthcare costs are on the rise. They're on the rise anyway, even without it. We are seeing more finances for disability and workman's compensation. The loss of productivity for prescription drugs alone went up to $53 billion. And, none of us have that money to account for, but that is during those times where staff are not at their fullest capacity, and it's not because they haven't had coffee, it's because they've taken something or ingested something, and they're losing time. They get hurt at work as a result of utilizing something. Now you've got workman's comp going on, which you'd still have to do because the workplace injury, the removal of the employee would be something you could potentially do far after this occurrence, but in the beginning, you would still need to provide them all of the things that you would provide another employee under the same circumstances. If you do for one, you do for all. Productivity is in lots of different veins. So it's work productivity, it's sales productivity, it's organization productivity. Has the culture changed in the office? What are those differences? All of that, the things that make up your organization being as productive as it is, gets calculated into this. And we all as businesses work really hard for our clients and to keep our clients, you won't want someone coming in and damaging that further. As I was saying earlier, one of the things that you can use is the Smoke-Free Air Act. This means that people cannot smoke on your property. And as we all are aware, marijuana is something that in one of its forms you are smoking. So this keeps people off of your property who may choose to use it. You know, I'm not against someone utilizing it for medical purposes clearly. However, the rest of your employees still need to be protected. And as HR, we're an advocate for the company and an advocate for the employee. Alcohol has never been made a prescription for me that as far as I know. If someone said to me, go home and take 2 cocktails and put your feet up, that was my prescription, I'd darn sure be doing it every day. However, that's not how it works. There's no prescription. There is no doctor saying you're too stressed at work, you should take a beer with you. We need to be mindful because lots of folks will say, well, smoking pot's just like having a beer. No, it's not. Marijuana can last in your system for 30 days. If you have a drug test within a 30-day window of having it, you're going to come up positive. 30 days worth of, are my reactions correct? Am I fast enough to hit the gas? Am I strong enough? Am I paying attention? Alcohol occurs for a set period of time, and once you stop taking it, the effects wear off sooner. This is a totally different animal that we have to deal with. So, to screen or not to screen, that's the question. You can still do pre-employment testing after a conditional offer is made. You can comply with federal law and say it's zero tolerance. No one can fault you for that. The difficulty could be the ADA is going to say, well, you have a zero tolerance policy, but did you consider an accommodation for this person because they are having treatment for cancer, they've had, a bone degenerative disease, they have whatever comes up. Have you done your due diligence and participated in the interactive process? And if you say no, you own that employee still and they have a job. You can do it post-accident. Sometimes people want to, limit it because of ADA or OSHA. The reality is you still need to do that. In my mind, OSHA is going to say to you, did you test this person after the accident? And when you say no, they're going to have a bigger problem with it. You can get flawed testing. We are seeing folks use CBD oil for, knees that hurt, for elbows that hurt, for wrist joints, etc. That is absorbed into the body at that point, much like a Bengay, of course, but it could flaw the test. So you need to be mindful of that, and potentially you're going to ask some questions to the person who's come up positive on the blood work test. You want to stick with your best practices for your injury. If someone has an injury and they're a driver, and your best practice is they're out of work until doctor approved, doctor must provide medical note that says each of the items they are eligible to do from looking at their job description. So they come back, they're on light duty, you stick to what is said in your best practices. We know what our industries will say to us about, can somebody lift this? Can somebody push this? Can they carry this? Can they drive this? Stick to those responses. If a doctor says, no, he can't drive right now, he's had major shoulder surgery, he won't be able to handle the steering wheel. Okay, he's not driving. Different person comes in, and now this employee, the doctor says, well, he could probably drive, however, he's on medical marijuana for his shoulder. Guess what? He's out on light duty, or he's not at work at all. Whatever we do with the first person is what we do with the second. You can test with reasonable suspicion, and this is a big one because you're going to have to train staff to recognize it. My recommendation has been, and I'm sure the state police will love you when you call them, is to ask someone to come out. I know at the high schools, they do programs with the young people where they'll bring in glasses that show you what it looks like when you're impaired from drinking or doing drugs. Have them come in and go through a training with your staff. It's safer to have outside come in and do those trainings and bring their knowledge base to support it, and have your frontline staff trained, because they're the ones who will be able to mitigate risk for you faster than you. You may not see that person. You know, there's days that go by, you don't see all of your staff because of schedules and work products. You can request if the person is fitness for duty, stick to it. This is where we'll also tie into the Diane B. Allen Equal Pay Act, those essential functions. If after the Diane B. Allen Act came out and you didn't go back to every one of your job descriptions and start staring at those essential functions, you need to do it now. Because when someone comes in who's a driver, who works with children, who works with the disabled, you need to clearly identify what those essential functions are, and in your personnel policy, clearly define what are not acceptable behaviors or acceptable treatments to something. You can do random, of course, which sounds odd when I say it has to be a uniform policy, but you know, you've got to have that lottery-based system where everybody gets hit at least so many times a year. Roadside testing, I brought this up earlier. Right now, we have a series of states that are testing it. 21 states at this point are accepting electronic transmission of warrants. So the police officer pulls up behind a car, gets out of the car, license and registration, please, observes the driver, and comes to the realization that this person is impaired in some way, shape, or form. He may have them get out of the car. He may make them do a DUI test, all right off the bat. Well, it might not be that. He's seeing other things that are, and or he's found marijuana on the seat, in the car, etc. You know that part in all the TV shows where they bring the canine out and he goes and does his job and we all cheer for the dog. Well, that officer can get in his car and transmit a request for an electronic warrant to the judge on duty at the time, and that judge can send back for the warrant. What that warrant does is it calls the police station next, and it has a blood draw van come out to the location and immediately draw blood from that person. That is potentially going to get challenged as an invasion of privacy, but it has not been challenged yet. Drawing that blood then, yes, I already said it stays in your system for 30 days, but it degrades in your system. So if his number is higher than average, so to speak, then we can assume that he's recently had marijuana of some sort. If it's very low, then clearly he's had it in the past. He may not be impaired right now. Something else could be going on. We also know as educated individuals that, you know, sugar-related issues, diabetic coma, diabetic shock look like someone who is impaired. So that's why we let the professionals figure that out and do what they need to do. The opportunity for this is big. I've often said in some of my sessions, if the first person that comes up with the test for this, that you blow in the mouth just like the DUI test, is going to be a billionaire. So if anybody wants to work on that, email me and I'm in. Congress right now is toying around with the Marijuana Justice Act, and this is from Senator Cory Booker. This would declassify marijuana to a Schedule I controlled substance, essentially making it legalized on a federal level, meaning every state in the union now. The next piece is they're looking to do a strengthening the 10th Amendment through Entrusting States Act. And this protects the states that have marijuana industry from federal intervention. This kind of goes back to support that banking item. If banks were permitted to accept that funding, we would garner more taxes, we would improve our base, so to speak. The local municipality would improve its base, etc. So these are some things, and as they're all coming out and I'm reading them, it's a roadmap to moving to a far more legalized system than what we have now for marijuana. So the best practices here, and I always love best practices. Keep up on the latest trends and changes. Many of our networking groups, especially NJBIA, put on at least 100 presentations in a year, and they are very important to keep you interested in understanding what's going on around us, because none of us have time every day to read everything that gets published. Train your managers to spot the signs of impairment. Often, you'll get that one manager who can smell it at 200 yards. That's great. However, making an accusation is not something you want that manager to go do on their own. You would want to, have a policy and a plan on how you would address the employee. Seek legal counsel. Have them look at what your personnel policy says. It's safer to pay the money to have them look at it to keep yourselves out of court in the future. Putting that money up now saves you money later. Know the legal aspects that impact your industry in our state. If your industry, if you get, federal grant money or specialized money or something specific from the state that you cannot lose because that supports your business and the product you're putting out, find out if that's an issue with someone having a medical marijuana card. And right now, we don't have an official list. I tell folks, contact the state, ask questions. The more questions we ask, the more they will develop the regulations to pair it into what it should be to support us as businesses. And educate your staff about the personnel policy. You may be very fortunate, like we are here at Primepoint, that you have, staff who've been there for 15 years. And they're wonderful and they're fabulous. They haven't looked at that personnel policy since the first time they signed it with you. You need to brush them up on it. Make it a once-a-year get-together, feed them lunch, everybody look at the personnel policy. Let's talk about the changes for this year. Right now, as I said, ADA is not requiring to be an accommodation. However, they're going to want to make you do that interactive process. So be ready for it. With your personnel policy, be proactive, educate yourself. Quite frankly, put a pin in Google Map where your businesses are and do a 50-mile radius and figure out, are there any dispensaries in your area? Are there any stores in your area? What is there in your area that you need to be mindful of? Get all the leadership involved. It's great to have you all on this call today, but there's probably a dozen other people in your office that really could have benefited from listening to something. Create your policy, require all staff to sign off on it, either electronically through an employee experience or on paper. Doesn't matter what you do, just make sure you have that document that says they read all of your policies. Be prepared for someone to come to you once the new policy comes out and says, I'm a medical marijuana user and here's why. Okay? They should present the card to you. You need to have your plan and what your reaction and response is going to be before they come to your office. Train your managers to address and document suspected or impairment correctly. I can't express to you enough, and I'm sure lots of you say it to everybody else around you, document, document, document. Make sure they're documenting the right things. Who's the witness? What time was it? Why do you think they're impaired? What did you notice that made them impaired? What were they wearing? What were they doing? You got to go through who, what, when, where, why multiple times before you get that documentation strong enough to protect your organization. And be consistent. Do for one, do for all. With your policies, you're going to set the ground rules, and you're going to start with putting it in writing, okay? You're going to look at the justification. We are committed to protecting the safety, health, and welfare of our organizations. And that recognizes that abuse of alcohol or other drugs compromises this dedication. Define the prohibited conduct. You can't have, you're not allowed to bring in, you may not share, you may not discuss. Think about the consequences of someone who has a bowl of candy on their desk and some smartass puts stuff in there that is potentially marijuana. Look at and define very clear consequences for violations, okay? If they refuse to take the test, if they fail a test, if they, what we're seeing with some folks is some companies don't even care about the test anymore because they're having a hard time finding good staff. What they're more concerned with is the job description and what the folks are doing. On the other side, we have folks where they're testing, and as soon as they give that notification to the potential employee that they're going for a blood test, the person never shows back up again. They unselect themselves from the possible job. Creating your policies got to be abiding by both state and federal. That still means you can have a drug-free policy. Complying with ADA, that would be your interactive process. Define your prohibited behavior. You may not do, blah. Define potential discipline. Testing, if you don't care, don't test. If someone's coming back to work, require medical certification from them. Make sure that, you know, a doctor's not necessarily going to tell you that they've prescribed Oxycontin to someone. And that's where our problem comes in. We don't necessarily know that, you know, Bob came back to work after hurting his back on Oxycontin and he's taken it all day. You may end up with a limited zero tolerance. Again, with job descriptions or ADA, you got to look at what are the specifics of this job and does this person, what does this affect that person? If the person's not driving, if they sit at a desk, if they're answering calls, if they're in very limited risk areas, you may have to allow them to have a medical marijuana card. On the other side of it, if they're in high risk areas, no, you don't have to accept them for a position. So some things to think about: is recreational marijuana legal in your state? Define each state you have an office in. Is your company required to be drug-free? Medical industry, police departments, municipalities, there are many that are required to be drug-free. What is the actual language of the law in your state? The law document itself is like 189 pages. I don't suggest reading it all, but read up. Every law firm posts out their articles because they'll do the research for us to go and look at what the hot spots are. What are your specifics on the random drug test? Make sure you've got it clearly defined, and who's the lottery, and is it a blind lottery, and et cetera, et cetera. And then, is a person unable to perform their duties? Not for nothing, on nights when I don't get enough sleep, I may have a tough time performing all of my job duties. But that second cup of coffee comes and I'm way better. So it has to be witnessed. You have to see that someone can't perform the duties or the job that you're expecting them to do. And that, my friends, we look at what are the exceptions, okay? On-duty use or impairment? No. Is there an undue hardship? It could be. One of the things I've been talking with a lot of HR groups lately is we have this thought of, it's succession planning. We've got to be prepared if someone leaves. What about substitute planning? You know, if someone is on medical marijuana and God forbid they're a cancer patient and they're undergoing treatment, we're going to keep that job for them. They're going to go on FMLA. You know, the expectation is we want them to come back whole. They're part of our team. So how do I get a good sub to fill in for that person? And NJBIA has some wonderful opportunities to meet professional substitute programs, professional temp programs, accountants, bookkeepers, you know, those kind of caliber of folks that you're not looking for frontline, you're looking for a thinker who can manage and be supportive to the department right away. You don't have to violate federal law, DOT regulations. You are removed from the position. You just won't be allowed to drive again. They're going to take your DOT card. And if there's the potential that you could lose a federal contract, then yes, you can have a drug-free workplace. It doesn't necessarily require that you test or fire the person. If you can move them into something else, you can do that. It's going to be a question of what is the actual responsibility. And that is all I have for today.
Okay, thanks, Judy. We have a couple questions already, but I want to give everyone else a moment to type in anything they have. I know we're coming up on that 12 o'clock hour. If you have to go, you have a meeting, you have lunch, whatever, by all means go. We're recording this session, and it will be sent automatically to everyone who registered sometime tomorrow afternoon. But for everyone else, I'll take a second to remind you about the Handouts tab. We get a lot of questions from people about how to download the slides. So just open up the tab marked Handouts in your GoToWebinar panel. The file is right there. You can also just wait until tomorrow. They'll be emailed to you along with that video recording. And there's the questions tab. If you have a question, type it in right there, and I'll make sure our guest answers it. And don't be shy. You've got an expert here, so make sure to take advantage of her. Can't tell you how many times I read the post-webinar evaluation. I hear somebody tell me like the webinar was too broad, it was too in the weeds. This is your opportunity to take it in the direction that you want it to go. So with all of that out of the way, we're going to jump right into our first question from Jim, who says, we have a new employee that is a medical marijuana user. He signed an agreement that the substance will affect his performance with his job, and he will not use the substance at work or on our property. If we smell marijuana on him, how should we respond?
Well, if he's signed it that he's not going to use it on the job and or have it impair him at the job, the one problem you have is that prior to getting to work, he's home. And so he may be utilizing it there, and he would smell like marijuana. The question is, first, is what are you going to put in your personnel policy about it? Because just because you smell it doesn't mean he's necessarily impaired. And two, have the conversation with him. Say to him, you know, we know you're on medical marijuana. We completely understand this. However, professionally in our business, when you come into work, on occasion, the odor of it is there, and we don't want to offend anyone in the organization. Is there a way that, you know, we could support you in changing your clothes, you know, getting another uniform, something where he's got to recognize that this is a two-way street and you're willing to work with him, but he's got to do his part.
Okay. Fran asks, we are a YMCA with child care as well as adult care with residents in our care. We currently have drug testing as a pre-employment condition. Are we covered as an employer to continue our drug-free environment?
Absolutely. And as a former YMCA employee, I worked for the Ys for about 20 years. You can continue your pre-drug testing, and you can do random drug testing of all of the staff that work for you.
Clifford asks, we are a dental office that accepts Medicare and Medicaid or Medicaid payments. Sorry, I have to rephrase this. Is a dental office that accepts Medicare or Medicaid payments considered a federal grantee?
So I had this conversation with several care facilities, and the things that we ended up kind of narrowing down to is Medicaid and Medicare are things that I pay into as a person. You are accepting a payment of fees from my work. You're not under a contract. They're not going to say to you, you need to treat 25 Medicaid people, and and we'll contract with you to treat these 25 people. It's the person coming in and wanting to use the benefits that they have accrued over their lifetime of work. So I don't see it as an institution where the Fed would question it, because that Medicaid and Medicare money is on the patient. It's not a direct line to the employer. You actually have to have the patient come in your door and request your services first.
Bill asks an interesting one. Who determines the definition of under the influence?
This is why I suggest having the state police come in. As a child, my father was a police officer, and even then I grew to realize that one person's definition is totally different than another. But when they do DUI checks, they have standards of what they consider impaired, and I don't know those, but that would be why I would have someone in that industry come in and train your staff to identify what that means.
Carrie says, we have a drug-free workplace. What happens with an employee who has prescribed medical marijuana and fails a random drug screen or a drug test post-accident?
Well, one, they have to have their actual medical marijuana card. And it sounds like you would have had them documented that they have this, correct? I would think. Post-accident, you would have to treat them like you treat every other employee when it comes to driving. The blood test that they would do for that person should be able to give the agency who does the blood work a range of where that person was at in terms of it in their system. So, for example, your drug-free workplace says you cannot be impaired or under the influence of. That person who had an accident may have been under the influence, and therefore they are bound by all of the legal actions that would have to be taken. If this person drives for you, though, if it's a DOT or something along those lines, they may need their license revoked from the DOT, because the DOT is absolutely no fly zone. You cannot do this with medical marijuana.
Heather asks, we also do drug testing before hiring employees, but we are a glass manufacturing company, and we state that we're a drug-free tolerance in our company manual. So our warehouse workers work with dangerous glass, machine, and forklifts. Can we terminate them if they come up positive, even with a medical card?
The first thing you would want to do is go back to that ADA stuff we talked about, and you would want to understand why they are taking this. Because when and if this person got an attorney and went to the ADA would come and they would say, did you go over the interactive process? Meaning, you can't work out there. It's a dangerous area, which I totally get. We have a drug-free policy for the plant. Is there another position the person can be in? And if there's not, we have seen recent court cases where accommodations could be demoted or terminated. Because if you can't do the job, you can't do the job. So it's a question of why are they taking it? What is the actual diagnosis? And then two, why are they post-accident, which I don't know what that might be. It could be a lot of different things. But post-accident is going to define, or the fact that it's dangerous, I should say, is going to define what they can do. If they are categorizing a disability that shouldn't be out on the floor anyway, and because they may not have the strength, they may not have the reaction time, they may not have the ability, then you could remove that person from that area. If you can find an accommodating place for them, that's great. If you can't, then I would talk to your attorney and draw up an interactive process plan, and one of the accommodations potentially being no longer work here.
Okay, we got one more here, but if you want to keep sneaking them in, we'll keep the webinar rolling. So Eli says, we are a crude oil processing plant that has a zero tolerance policy and no interactive process. After the appellate division holding in Wild, can this policy still be defended?
The interactive process part you would have to do. And the interactive process part isn't just for someone who's utilizing marijuana. It's for someone coming back from workman's comp. It's for someone coming back from their own injury outside of being at work. You can keep the whole policy, but you will be expected to have that interactive process. And again, if you're a refinery, correct me if I'm wrong, but you're in an industry that is heavily regulated by the Fed. Okay. So that gives you an out there too.
Well, that looks like all the questions we have, so I think it's a good time as any to bring things to a close. Don't forget, all of you will be receiving a recording of today's webinar and the PowerPoint slides via email. Lastly, when you close out of the webinar, a survey will come up on your screen that we hope you'll fill out so we can understand how to best provide you important information in a webinar format. Our next webinar, Effectively Managing Your Gas Costs, will take place January 15th, so by all means, feel free to register for that one right on our website at njbia.org. So until next time, for Judy Saylor, this is Vinny Civitello thanking you for being with us this morning and wishing you a great day.